Folks, without further ado, I don't think I need to spend any time introducing him, J.B. Van Hollen, our Attorney General.
Thank you, Terry.
Good to see you.
Thank you, Terry, and thank you all. And of course, I will start with the obligatory apology for being late. For those of you who know me well, you will know that perhaps my biggest pet peeve in the world is tardiness. So when I'm late, it bothers me twice as much. Who would have known it would take us an hour and 20 minutes to get here from Mequon? But it did. We thought we had bartered enough time, but you know, it just goes to show I don't live around here, huh? Thank you so much for being here. I really appreciate your interest. You know what's so amazing is when we can get a turnout of Republicans and interested parties so regularly like this. To hear that Alberta Darling is going to be here tomorrow night as well, and I'm guessing you'll have as good or better turnout then as well. That speaks volumes about what we're able to succeed as a party with boots on the ground. The bad news is, and obviously the reason why I've been invited to speak here, or actually offered up to speak here, is that we're going to probably need more boots on the ground than everybody else, like we always have. The reality is the Republican Party has had to work harder than everybody else because we've had to battle the mainstream media and many other challenges that face us. And now in Wisconsin, we're going to have one more election, much like the recall election, where we're going to have to battle without photo ID for voting, and we're going to have to battle against voter fraud because of court rulings that I, of course, have great animus towards, I guess you could say, and I'm sure all of you do as well. My reason in coming here is to be able to answer your questions, to kind of explain what's going on. I know, and I talk about this all the time, because as I travel around the state, I try to talk about a myriad of things that we do in the Department of Justice, because very few people understand truly all the different things we do in the Department of Justice. Very few people understand within that what our appropriate role is within the context of those subject matters, nor what we're doing in any given particular case, because the papers don't do us any justice, sound bites don't explain complex legal cases, and quite frankly, the reality of Madison, and I hate to use those two words together, is just a whole different world. I can tell you, and I think maybe you've already seen her, Maria Lazar is here. Wave your hand, Maria. Maria is a relatively recent attorney to our office, not a recent attorney, however. We hired Maria to do predominantly, I'm proud to say I got to hire her as one of the many attorneys I hired to do predominantly bankruptcy work. Since then, she has done predominantly government work. And that has been because she has shown herself to be a rock star and has shown herself to be quite the litigator, and we have used her for litigation and for discussion of litigation in all the significant cases that we've been handling in the Scott Walker era. And so she's here because since she has been intimately involved in prosecution, wow, there's my roots, in litigation of 3 of the 4 photo ID cases that we have in the state right now, there's a high likelihood she's going to be able to answer some of the questions that I can't answer. She's also been out in the field as one of the many attorneys and or cops that we send out into the field on election days to try to make sure that we have people at the polling places to respond to election officials when needed, so she can comment from firsthand experience on what that's like being in the field as well, and the sorts of things that we can do and can't do and should do and shouldn't do. Well, and I'm sure I'm speaking beneath most of you because you're here, you understand what's going on with the voter ID cases. The reality is, and I almost have to back up, what's been so disgusting, quite frankly, about this last year and a half, and it's hard to say that when Republicans have controlled almost everything, is that when the Democrats were in control, an awful lot of things happened that the Republicans didn't like. Governor Doyle and the Democrats pushed through a whole bunch of crap that we didn't like, but we realized that they're the policy-making body, they had the prerogative to do that, and we swallowed hard, decided that we would turn out and we would make sure that the general public understood what these bodies were doing and throw the bums out of office. And they did. I think that that is the way that an electorate responds to governance that they don't like. Well, of course, I think the liberals realize that the general public like what we do and they don't like what they did because they threw them out and we got elected with overwhelming majorities. And so what happens now is they can't go appeal to the public because they're against photo ID for voting, or because they're against concealed carry, or because they're against Act 10 and things along those lines, because they know the general public's on our side. So unfortunately what that means is they turn to the courts. And the courts are, of course, an incredibly interesting animal. And for any of you who have ever worked in the court system, you will realize that the rule of law certainly doesn't always prevail, and many times doesn't prevail. I say this against my best interest, and I always say things against my best interest, I guess, but I mean, I actually had one time years ago a jury trial. I mean, I kicked butt. I did a great job. I even got the defendant to break down on the stand and confess to the crime, and I lost. You never know what juries and judges are going to do. They can say they don't care about the law, they're going to do what they wish the law was or come up with a result that they want. It happens. And unfortunately, it happens all too much. And so what we have to do is we have to continue to battle against that, which is what we have been doing in the Department of Justice in a number of cases. Of course, we prevailed using a unique procedural mechanism in Act 10 in the state Supreme Court. We then prevailed predominantly on Act 10 in the United States District Court for the Western District of Wisconsin, with some small losses on Act 10 that we are now appealing. We have been very successful, I think, in our redistricting appeal. We lost a couple of small issues that philosophically are huge as far as activist courts go, but not necessarily big enough to justify the huge expenses and the potential downside of appealing those cases. But when it comes down to voter ID or photo ID for voting, of course, we've been losing across the board. And we've been losing across the board in a very, very disappointing fashion. You know, people talk about Dane County judges, and I'm a little careful as an officer of the court of calling out a court. I'm the first one to be critical of President Obama when he has twice very publicly called out the Supreme Court for doing their jobs. And so, as an officer of the court, we have to be a little bit careful. I can tell you that I vociferously disagree with what both of the Dane County Circuit Court judges in our two cases, Judge Flanagan and Judge Neese, have done on a number of different grounds. But I also have a considerable problem with the one Court of Appeals in the Judge Neese case, and the League of Women Voters case, and, quite frankly, with our state Supreme Court, who has made a decision that I have great consternation with, and I very much look forward someday when these cases are done to finding out on what basis that decision was made. Because we ended up with the luck of the draw. We got two cases in Dane County. Well, that's not luck of the draw, that's expected. Two cases that got filed in Dane County, one by NAACP predominantly, one by the League of Women Voters predominantly, and we just happened to get two judges who obviously favored their viewpoint. We believe we are very, very solid in the law. As a matter of fact, we have offered, my Department of Justice, since I've been there, repeatedly to help legislators and the governor draft legislation, Democrats and Republicans alike, to draft legislation to hopefully help them withstand constitutional and appellate muster when those statutes, once they become law, get challenged. Sometimes we're taken up on that, many times we're not. In this case, we actually were. We had attorneys in our office who worked very closely with the legislators who were working on photo ID to make sure that we believe, based upon other laws out there around the country, based upon current case law, that we had a case that we believed we could support would withstand constitutional muster. So we felt very confident going into court because we had the law on our side. And I believe we had the facts on our side as well. But you can lose despite those two things, at least in the short term, and you can in the long term as well, and hopefully we won't. Largely what has happened in our cases, to kind of put them in a nutshell, is that the judges have ruled that our Constitution, unlike the United States Constitution, let me back up. The United States Constitution, in the Indiana voter ID case, Indiana has already had their case upheld as being lawful under the United States Constitution. Well, our two cases, the arguments in Dane County were brought as our law was a violation of the Wisconsin Constitution. Believe it or not, there are differences. There's a lot of similarities, but there are differences. In the Wisconsin Constitution, unlike the United States Constitution, the right to, or I don't know exactly how to phrase it, there is a definitive declared right to vote. And that's what these judges have been hanging their hat on. Basically, what they have decided is this right to vote means that virtually there's nothing that the state can do to disenfranchise them. Very contrary to what prior Supreme Court precedent in the state of Wisconsin has said, Judge Flanagan, in our most recent case, actually cited a number of Wisconsin Supreme Court cases to back up his holding that our Constitution has been found to throw out voter restrictions in the past. But every case he cited were cases where voters were flat out blocked from voting. Blocks and groups of voters were flat out told, no, we're not going to count your votes, or we're not going to hold a new election because you were excluded from voting, and therefore whole blocks were denied the right to vote. What he is saying, and stretching this a little bit further, is saying that making it more difficult for these people to be able to lawfully vote is really along the same lines of legal argument. So he's made a legal stretch in that case, which of course we think we can counter very well, because I don't believe the case law supports it. I don't believe our Constitution supports it. And there's nothing in our history that supports the fact that you have to do everything in your possible to make sure one person perhaps has the ability to exercise their rights. The other area where Judge Flanagan failed, I think miserably, is on the facts. He had to have facts to apply to this new law he was making. And those facts have to be that it is difficult or impossible for a group or individuals in the state of Wisconsin to vote. And I can tell you that if he had not issued a temporary injunction before this case was even tried, saying that he believed that the petitioners were likely to win on their merits, meaning the state was going to lose, if he had not issued that, when I saw the evidence that came in at trial, I would have bet you big money we were going to win this case hands down. Any observer, casual observer, who listened to the facts and evidence and testimony come in, and the arguments that were made, would say, holy smokes, the state of Wisconsin has totally kicked butt in this case. They put forward, keep in mind that NAACP got to handpick, cherry pick who the plaintiffs were for their case. So they got to go out and they got to find the hardest luck cases of people trying to vote who were being deprived of their ability to vote for whatever reason. Yet, we were able to show at trial that every single one of their plaintiffs not only either had a photo ID and was entitled to vote, or could have obtained one, but did not do so because out of principle they didn't want to do so. They then reached out and they found a number of other examples. Was it 52 other examples? Somewhere along those lines. I don't know the exact numbers. We were able to show all but 5 of them, I believe, had the ability to get a photo ID. And the other 5, even though we did not show that they had the ability, the plaintiffs were never able to prove that they had the inability. So even with the legal stretch of Judge Flanagan, he had no facts upon which to find that people are being deprived or challenged for the right to vote in Wisconsin upon which to rule. And to make matters even worse, I think the third significant problem we ran into is that he then entertained the balancing act. I don't know that of a time that this has necessarily occurred in a case such as this, maybe because there hasn't been a case quite such as this, but balancing the interest in the state in passing such a law with the need to pass a law. Basically, the judge was entering into the realm of policy. The judge was trying to do the job that we, like our legislators and our governor, to do, and saying that, you know what, this law really isn't needed. Because even if you argue it barely disenfranchises anybody, you can argue that there's barely any fraud that it protects from either. So we have 3, I think, pretty significant errors that came out of this case that I think we have a real probability of turning over an appeal at one level or another. And this particular case is going to end up in a different appellate court than the first case, of course, and I'll get into jurisdiction a little bit. I'll kind of talk about the whole jurisdictional aspect of things. So when these 2 cases first came into Dane County Court, of course, Judge Neese ruled right away that the law was unconstitutional, threw it out, and issued a permanent injunction. Judge Flanagan, of course, that case got set for a trial. It wasn't decided on summary judgment, but he issued a temporary injunction saying that we could not use photo ID. We, of course, wanted to find every way possible to to get those injunctions stayed or overturned as fast as possible. First of all, it's our job, the Department of Justice, to defend and advance the will of the legislature and the governor in making policy. And second of all, it's very important, lacking confusion to the public, if there's a voter ID law that already had been implemented very successfully at one election, that we don't go flipping back to the old way again and leaving the public with an unknown. And then, of course, there's the policy perspective of the need to make sure that that we have integrity at our polls, because I can tell you our office puts considerable resources into trying to maintain voter integrity and to investigating and prosecuting cases of voter fraud. We put a ton of time and energy in the Department of Justice into that. So there are a lot of reasons for us to be out there actively defending this and trying to get the case moved along as fast as possible. So what we did is we immediately asked both judges to stay their injunctions pending the appeal. So we asked both of them to say, can you change your mind? And can you just allow the law to stand until this runs its course? They both said no. We then asked the appellate courts to do the same. And just so you know, these two cases went to two different appellate courts. When this new law that created the Government Accountability Board was passed, it changed venue on some cases. One case, very notable here, is it allowed Scott Jensen to be prosecuted here versus in Dane County. Well, that law also changed where appellate court venue is. It used to be kind of a silo methodology that if there are 4 courts of appeal in the state of Wisconsin, if your county lands in one of the jurisdictions of one of those courts of appeal and you're appealing from that county court, you appeal to that court of appeals. Well, to try to provide a little variety between Democrat and Republican parts of the state, not that politics is supposed to play a role in the court of law, they changed that and said that any appeal that's brought from a court has to be brought in an appellate district other than the one in which the county resides. And the appellants get to pick which of the 3 other ones they file the appeal in. Well, the Denise case was filed under the old law, and so that case naturally went to the Court of Appeals that handles southwestern Wisconsin. The NAACP case, the Flanagan case, fell under the new law, and so we as appellants got to pick the jurisdiction where that appeal would take place, and we of course picked the Court of Appeals here at Waukesha only because of its physical proximity to Madison. Thank you. I was wondering if I was here alone. Just keeping you awake.
So the first one was in Dane.
What? First one's in Dane, correct. And so we asked these 2 different courts of appeal in these 2 different Dane County cases for stays of the injunction. Neither was granted. We asked both of them to certify the cases to the Supreme Court, meaning they say to the Supreme Court, please take the case and bypass us. And there are certain reasons that you have to give why that should occur. We had a great argument in both these cases. We laid out the argument very well. I'm expecting that perhaps the 4th Circuit Court of Appeals in Dane County is going to say no, because they perhaps want to drag their heels on this if they want to let politics influence what is happening. Well, much to my amazement, we get 2 different Court of Appeals at the same time agree to certify both of these cases to the state Supreme Court. Then, I tell you what, I was laying awake at night giddy at how rapidly we were going to have success. Nobody was astounded more than me when the Supreme Court basically said, deny. Nothing more, nothing less, no explanation, just left us hanging there with a deny. What that meant was that the one case that was permanent went back to the Dane Court of Appeals to start the process. The other case got kicked all the way back to the Dane County Court for a trial. We then asked both of the courts, one second, I'll finish this procedure and I'll take questions. We then asked both of those courts to actually, well, let me back up. We asked the Court of Appeals that was hearing a case to expedite that appeal. Not only did it not get expedited, but I think they didn't even respond to our request to expedite the appeal. Did they respond? Okay. Oh, they didn't expedite the briefing schedule, but they expedited looking at it, whatever that means. They're going to look at it half as slow as they normally would look at it. So the other case got kicked back to Dane County for a trial. That's the trial that I already discussed that I thought we won with flying colors, and of course we came up on the losing end of that. That case, the good thing about having a final judgment in that case is we got to appeal that case very, very rapidly, which we did to this district again. We will be trying to move that case through this district as rapidly as possible, and we are thoroughly exploring the various legal mechanisms we have at our disposal to potentially ask the state Supreme Court to take these cases again. No reason to expect they necessarily will, but now that we have a final judgment in the second one, and they actually have a legal decision and a judgment and a fact basis to actually work with, maybe, just maybe, we can get these cases in front of the state Supreme Court again. I'll answer a question, then I'll continue. That way I get to drink water.
Mr. Attorney General, how many votes do you need from the Supreme Court to take up the case?
3, I believe.
And out of 4 conservatives, we couldn't get 3 votes?
It appears to be the case, correct? All right, so we move forward now. We have these cases in 2 different courts of appeal. Even if, best case scenario, we get these cases to the Supreme Court again before they go through the appellate court process. Best case scenario within that, the Supreme Court stays the injunctions in both cases, and we therefore have photo ID to vote again. There were 4 cases filed in the state of Wisconsin against photo ID for voting. 2 of which there are rulings on, 2 of which were filed in federal district court here in the Eastern District of Wisconsin, which were consolidated into 1 case. Those cases are currently in the discovery process. Those are Maria's cases as well. Those cases, there was a motion for a temporary injunction filed by the plaintiffs as well. The judge in those cases had stated that he did not believe he needed to take up those motions because there were at the time 2 injunctions that were already implemented, making him taking them up moot. However, if for some reason we would get this case before November to the Supreme Court and get them to stay the injunctions, which would be the only way we'd beat November, because if we waited until they had a ruling, it's even getting too late. Federal court, has the opportunity then to take a kick at the cat as to whether they're going to enjoin the law. And without getting too much into detail, we have every reason to believe they would. So the long and the short of it is our prognosis for having photo ID in November, I think, is extraordinarily slim. Regardless of all the procedural maneuvers that we have tried in DOJ, regardless of the law being on our side, regardless of the facts being on our side, the prognosis is extraordinarily slim. That's just the reality of the situation, and there's not a whole lot we can do about it when you have courts who are willing to take these measures. The good news is I really believe that we have the law on our sides. And despite the temporary ruling of not taking the case by the state Supreme Court, I have very great confidence that our state Supreme Court is well positioned to listen to the law and make the correct decision when this comes to them. I can also tell you with regards to the federal cases, regardless of what happens in district court, I think the likelihood of success in the 7th Circuit Court of Appeals, where we would appeal that, is quite high based upon jurisprudence there. And then, of course, despite the most recent decision by our United States Supreme Court on voter ID, they have certainly sided with our side and our legal arguments. So that's an awful lot of yapping by me. And I'm sorry, but I had to try to do everything I could here to set the table. And now I'll open up for questions.